Hi friends, how are you? Hope you are doing well. And I have come with a new topic, and this is very important topic for your understanding, and it is also related with our judicial structure institution of this country. That how judiciary has decided certain things and how parliamentary form of government is working in this context. So I'm going to explain and discuss about the presidential reference, right? What is it? The first question is that what is it? What is the presidential reference? And it has been become a very important news in many newspapers. Many experts, legal experts, have explained about the presidential reference, that why President of India recently have referred certain questions to Supreme Court of India, and why those 14 questions are very important, and what is the context, in which context it has been immersed, which is very important. So in this discussion we will discuss about the constitutional provisions, we will discuss about the controversy surrounding this presidential reference, why government of India has taken a stand, this kind of a stand, whether it is the first time or it has certain history before this reference, and different questions asked by the President of India to the Supreme Court of India, and what is the Supreme Court of India's stand in the past, and what might be the stand in this case also. So there are a lot of questions regarding this presidential reference which we need to explain, we need to discuss, and we need to understand what is the presidential reference, right? So first of all, we would like to understand the first question, that is the what is the presidential reference, and under which provision of Constitution of India it has been mentioned. So first of all, I will give you a reply that yes, there is a provision in Constitution of India, and that is under Article 143 of the Constitution of India, in which the President of India, and of course you are knowing that under parliamentary form of the government, the President of India or head of a state means head, first citizen of India means President of India, will act according to aid and advice from the Council of Ministers. And you know that in parliamentary system, the head of Council of Ministers is Prime Minister of India. So, on the aid and advice of Government of India, the President has power to ask certain question on the substantive question of law or fact of law, right? So, the President of India is authorized under this constitution to ask certain questions, ask certain opinions. So try to understand, I am saying the opinion, right? So President of India can seek opinion of the Supreme Court of India on certain aspects of law, certain aspects of fact, right? He is authorized, she is authorized. So under this article, the President of India has asked 14 questions to Supreme Court of India, and certainly Supreme Court of India has power either to give a reply, give opinion on those 14 questions, or to deny, right? So the first thing is that yes, there is provision in Constitution of India under Article 143, and under which the President of India may ask certain question, refer certain questions. Actually the reference word is being used, and when the decision will come from the side of Supreme Court of India, that case will be named in this way, in re certain words, right? In re Union of India versus something like that. So in re means in reference. So this is the reference to the Supreme Court of India by the President of India on certain aspects of law, and that is generally substantive question of law or substantive question of fact. Right. So under this article, it has been referred to Supreme Court of India. Now the second question is that why this reference has been made. This is very important. So there was a case filed by the state of Tamil Nadu in the Supreme Court of India regarding the 10 bills repassed by the Legislative Assembly of Tamil Nadu, and it was being withheld by the Governor of Tamil Nadu. Right. It has been withheld by the governor of Tamil Nadu, and after that he also sent it to the president for consideration of those bills. So the question in that case was before the Supreme Court of India that whether there is time limitation for the assent of that bill or not. And it has been reported in the Hindu newspaper that there is a office memorandum of the Home Ministry in which the governor has been instructed, the president office has been instructed and advised to give assent on those bills or on bills within 3 months time period. And on the basis of that office memorandum, the two judges bench of the Supreme Court of India has decided that case or petition in favor of the Tamil Nadu state and against the governor of the state, and have instructed the governor office and president office to assent the bill within 3 months period. This was the case. This was the case. And after this case, because the Tamil Nadu state has won this case, and it has been decided against the office of the governor, and certainly in this case the Supreme Court of India, the two judges bench of the Supreme Court of India has held that within 3 months the president office and the governor office must give assent to those bills, because those bills are being passed by elected legislative assemblies, and the governor and the president of India cannot sit on those bills for uncertain period. And after this, of course, there was hue and cry. There were several questions and allegation on judiciary by the members of ruling party. So in midst of all these things, in midst of this decision by the Supreme Court of India, this reference has been made and certain question has been asked. The third point is that it is not first time. It is not first time. Many president of India have asked this kind of question from the Supreme Court of India. They have referred many questions to the Supreme Court, and Supreme Court has given it. So 2 points you need to understand. The first is that it is the reference to the Supreme Court. It is a reference in order to seek opinion of the Supreme Court on certain question of law and fact. It is not mandatory on the President of India to accept or act according to that opinion. First thing. Second thing is that in a reference, if some question has been asked in reference from the Supreme Court of India, they are not obliged to give answer on those questions. Remember this point. They have authority to deny. They have right to deny. They have power to deny. And in previous history, in past, they have denied on certain questions, on certain question being asked by the President of India, they have denied to answer. And third point, which is also important with these 2 points, is that the opinions sought by the President of India in this reference are not mandatory, and it is not going to influence the decisions of that bench which has decided that case in which decision has been given against the Governor of Tamil Nadu, against the office of Governor and President of India. It is not going to impact. It is just an advisory opinion by the Supreme Court of India to the President. President is not obliged, it is not mandatory to accept the opinion by the Supreme Court of India, and it is also not mandatory on the part of Supreme Court of India to answer each and every questions asked by the President of India. So it is advisory in nature. It is advisory in nature. So try to understand. Second thing which is very important is that as we are knowing that the office of governor is not an elected body, right? And even Sarkariya Commission, Pochi Commission, and all these commission which were constituted by the competent authority on certain center-state relations have said that there must be limit to this discretion, the discretion to give assent on bills passed by the competent legislative assemblies. And in line with this, there is two office memorandum by the Home Ministry. So whether it was necessary to refer this question, because lot of things are settled. In many cases, Supreme Court of India has held that this discretionary power is not arbitrary. If certain bills has been passed by the state assemblies, and those members of state assemblies are being elected by the people of that state, you cannot sit for uncertain period. The discretion given to you for the benefit of the people, benefit for the benefit for the larger interest of society. The discretion has not been given to violate the constitutional principles of limitation, check and balance. So this question has been settled. The office of the governor and office of the President of India is not above the Constitution. Constitution is the supreme. It is the supreme law. And we are understanding as a student of law and a legal expert that every discretion has certain limitation. If discretion is not utilized in favor of the people of India or under or within the limit of the Constitution of India, it may treated as arbitrary. So discretion cannot be used arbitrarily. And against this arbitrary exercise of the power to withhold the assent on those bills, the state of Tamil Nadu approached the Supreme Court of India under its original jurisdiction. Right? So 14 questions has been asked in this reference, and those 14 questions are very, very important. You should also know, and I think, and of course I know that most of us are knowing about those questions, because most of the questions are being settled by the Supreme Court of India in the different cases. So what is the first question referred in this reference is, what are the constitutional options before a governor when a bill is presented to him under Article 200 of the Constitution of India? Certainly we should wait for the answer given by the Supreme Court of India. So this is the first question. What are the constitutional options before a governor when a bill is presented to him under Article 200 of the Constitution of India? Second question is that, is governor bound by aid and advice tendered by the Council of Ministers while exercising all options available with him when a bill is presented before him under Article 200 of the Constitution of India? So most of things are clear that aid and advice, except in certain cases, is mandatory. It is very important, because governor is not an elected person, elected office. It is being nominated by the center. The person is nominated by the President of India. So aid and advice is crucial for maintaining federalism, from maintaining parliamentary form of the government, right? Third question is the exercise of constitutional discretion by the governor under Article 200 of the Constitution of India justiciable? So this question is also very important, that whether the discretion used under this article for giving assent or withholding assent is justiciable or not. Justiciable means whether it can be challenged in the court of law or not. The fourth question is Article 361 of Constitution of India an absolute bar to judicial review in relation to actions of governor under Article 200 of the Constitution of India? Right. So another question has been asked in this in this question is that whether Article 361 is bar on judicial review. Certainly this question will be looked after by the judiciary. Fifth, in the absence of constitutionally prescribed time limit and the manner of exercise of power by the governor, can time lines be imposed and manner of exercise be prescribed through judicial orders for the exercise of all powers under Article 200 of the Constitution of India by the governor? This is the crux of this reference. And of course, in the Constitution of India, the time limit has not been provided. Right? The time limit has not been provided. But the office memorandum and different cases decided by the Supreme Court of India has held that there must be certain time limit. There must be a reasonable time. And reasonable time doesn't mean that you can sit on the bills for uncertain period. You can withhold the bill for uncertain period. This power cannot be interpreted in that way. You cannot use that power in arbitrary sense. So this question will be decided by the Supreme Court of India also. The sixth question is the exercise of constitutional discretion by President under Article 201 of the Constitution of India justiciable? So another question of same nature, that whether the President of India, when a bill is being referred to President of India for consideration, so whether the discretion exercised by the President of India under Article 201 can be challenged in a court of law or not. And according to my opinion, yes, it can be challenged. The arbitrary power arbitrary power is antithesis anti to the right to equality. It is anti to the democratic right. It is anti to the justice. It cannot be justified. The President of India cannot sit over the bills passed by the competent legislative assembly for uncertain period. The discretion must be controlled, it must be restrained, it must be limited by check and balances, it must be limited by constitutional principles. The discretion is not above the Constitution of India. Constitution of India is supreme, and if it is supreme, the executive cannot be treated as above the Constitution. Right? The next question, the seventh question is, in absence of a constitutionally prescribed timeline, a manner of exercise of power by the President, can time lines be imposed and manner of exercise be prescribed through judicial orders for exercise of discretion by President under Article 201 of the Constitution of India? Similar question as question number 5. Whether that time limit can be fixed by the judiciary or not. So the question is that, of course, this question will be decided by the Supreme Court of India. If President or Governor is sitting for uncertain period over the bills, why time limit cannot be imposed? There is office memorandum of the Home Ministry, and if it is not, why Home Ministry has issued the office memorandum? It has also been recommended by the several commission as prominently Sarkaria Commission that there must be time limit. And I think also, according to my point of view also, there should be time limit. And the controversy has been erupted on this order given by the Supreme Court of India, that the governor and president of India must give assent within 3 months. And some people are arguing that it is direction to the president of India, head of the state, who has appointed the judges of the Supreme Court of India. The question is that who will interpret the law? It is the judiciary. It is the supremacy of the constitution. President of India office is not above the law, not above the constitution of India. Why she or he cannot be directed? They must be directed. If they have power, they cannot use that power arbitrarily. It is against the right to equality. It is against the due process. It is against the due process of law and procedure. So there must be direction, because without law, the development and welfare of a state, welfare of the people of that state cannot be done. Their welfares cannot be compromised by this exercise of discretion. The eighth question is that, in light of constitutional scheme, the governing power of the president, is the president required to seek advice of Supreme Court by way of reference under Article 143 of the Constitution of India, and take the opinion of Supreme Court when the governor reserve a bill for president assent or otherwise. So in this question is saying that, in light of constitutional scheme governing the power of the president, is the president required to seek advice of Supreme Court by way of reference under 143 of the Constitution of India, and the take opinion of Supreme Court when governor reserve a bill for president assent or otherwise. So this is also an interesting question, that if a bill has been reserved for the president of India by the governor, so in that case, whether the president of India can refer those questions to the Supreme Court of India or not. It will be very interesting question, and of course I think the Supreme Court of India will answer this question, right? Question number 9. Are the decision of the governor and the president under Article 200 and Article 201 of the Constitution of India respectively justiciable at a stage anterior into the law coming into force? Is it permissible for the courts to undertake judicial adjudication over the contents of a bill or in any manner before it becomes law? It is also a very important question. So in this question, the President of India is asking in this reference is that whether before becoming a law, suppose that there is a bill, and bill without assent by the president and governor, it cannot become a act, it cannot become a law. So in this question, it is being asked that whether the Supreme Court of India can decide before giving assent, before becoming a bill into a act or a law. So this is also a very important question. But the decision given by the Supreme Court of India in that case, which I have already discussed, was not related with the contents of the bill of content of those bills passed by the Tamil Nadu Assembly. It was just on the power exercised by the governor or power exercised by the President of India. So it might be very interesting, and it will be certainly answered by the Supreme Court of India. 10th, question number 10. Can exercise the constitutional powers and orders of by the President Governor be substituted in any manner under Article 142 of the Constitution of India? This is also very important question. And you know that under Article 142, a concept of complete justice has been enshrined by the constitution makers in our constitution, right? So, in this question, this has been asked that whether the orders, can exercise of constitutional powers and orders by the president governor can be substituted by the judiciary in any manner. It has not been mentioned as judiciary, in any manner under Article 143 of the Constitution. So whether in the interest of complete justice the orders and decisions taken by the governor and president can be substituted or not, this is also a very interesting questions. Question number 11. Is a law made by a state legislature a law in force without assent of governor granted under Article 200 of the Constitution of India? So this is also interesting question, that if the state legislature has passed the law but it has not been assented by the governor, because governor or president of India is competent authority to give assent to the bills, and then bills converted into the act, and then that act become a law. So president of India is asking that the deemed assent can be treated as a valid assent to that bill or not. So deemed means if the president of India and governor has not given the assent within a limited time period, and if 3 months has been elapsed, then whether it may be deemed as passed by or assented by the governor or president of India. This is also very complicated and crucial questions, because in this case the Supreme Court of India has allowed Tamil Nadu government, and they have said that if the 3 months period has been elapsed, it may be treated as assented. Means assent has been given to those bills. So this is also a very crucial question in this regard. Next question is that question number 12. In view of proviso to Article 145 clause 3 of the Constitution of India, is it not mandatory for any bench of this honorable court to first decide as to whether the question involved in proceeding before it is of such nature which involves substantial question of law as to interpretation of Constitution, and to refer it to a bench of minimum 5 judges? So it is also a very important question, because this question has been determined by the 2 judges bench of the Constitution of India, Supreme Court of India, 2 judges bench, right? And according to according to Article 145 clause 3, if the question is related with the substantive question of law, right, then it might be decided, it must be decided by the larger bench, not only division bench but a larger bench. This is also a very crucial question which need to be answered by the Supreme Court of India, need to be settled by the Supreme Court of India. And the 13th question is, do the power of Supreme Court of India under Article 143 of the Constitution of India limited to matters of procedural law, or Article 143 of the Constitution of India extends to issuing directions, passing orders which are contrary to or inconsistent with existing substantive or procedural provision of Constitution of law, Constitution or law in force? This is also very crucial, because this case was related with the discretionary power of the governor and president of India. It was not related with the procedural matter. So president of India is asking that whether it is limited only to the procedural matters or substantive matters. This is also very, very important, and I think the question will be settled by the Supreme Court of India. And the last question, which is also important, and that is the 14th question: does the Constitution bar any other jurisdiction of Supreme Court to resolve dispute between union government and state governments except by way of suit under Article 131 of the Constitution of India. This is also very, very important. So under federalism, the dispute between union government and a state government are generally settled under Article 131 of the Constitution, which talks about the original jurisdiction. It is the very integral part of the federalism. So President of India is asking that except these or outside this article, which is mentioning about the original jurisdiction, the dispute between central government, union government and state government can be settled or not, because many disputes has been raised by the state governments under the writ jurisdiction, right, under the writ jurisdiction, not under Article 131 of the Constitution of India, which is the original jurisdiction, right? So this is very, very important. So these questions are very, very important to understand which kind of questions have been referred by the President of India to the Supreme Court, and how many questions have been already settled, and how many questions are need to be settled by the Supreme Court of India. But remember, guys, remember, my friends, these opinions by the Supreme Court of India on these questions are not mandatory in nature. President of India is not obliged to accept these opinions, and even Supreme Court of India is not obliged to give answer on every questions. This is very, very important. This is the advisory jurisdiction of the Supreme Court of India, and it is power of the President to seek opinion of the Supreme Court of India on certain substantive question of law and fact of law by referring certain questions to the Supreme Court of India. So it is not mandatory. It is not mandatory. But try to understand the point is that which is very, very important, is that this is a kind of clash between the union government and the state governments. And it is bound to happen in the federal system, and it is happening. So whether it is correct, whether it is incorrect, it is a different question. Why central government has asked this? Why central government has recommended to the or advised to the President of India to seek opinion of the Supreme Court of India? There are some tricky questions in this 14 question list of the 14 questions, and we will see that what Supreme Court of India has said. And in past also, Supreme Court of India has denied to answer on certain questions, but on many questions they have settled the problem, settled the dispute regarding particular problem and particular provision. So this is very, very important decision taken by President of India, and we are hopeful that in coming days, in coming months and in coming years, the Supreme Court of India will settle all these 14 questions raised by the President of India on the aid and advice of the union government. So with this I will conclude this discussion. This is the very important, you can say, contemporary legal questions which has been referred by the President of India to the Supreme Court of India. This is very, very important, and you must have eyes on the development related with this. This is very important, because it is continuous problem of fight between dispute between central and state governments. There is a continuous fight regarding the misuse of the governor's office. They are unelected persons. They are holding unelected office, and they are using their power in order to manipulate the state government, in order to hamper the welfare of the people, and especially if there is a central government at the union level ruled by different party, and the state government ruled by the opposition party. This is the continuous clash. So these questions need clarification. These points need to be settled by the Supreme Court of India, so that our federal system, our constitutional mechanism will run in flexible way. So with this, I will conclude this discussion, guys. And if you like my video, if you like my discussion, please subscribe my channel, like my videos, and share as far as possible. So with this, I'm concluding this discussion. Thank you so much. Jai Hind, Jai Bharat, Jai Samvidhan. Thank you so much.